I welcome you all for the 152nd webinar of the Madras Tax Bar. Today's speaker is Senior Advocate Mr. Ramakrishnan Veeraraghavan, who accepted our request readily to take a webinar on one of the landmark decisions of the Supreme Court in the case of safari retreats. Mr. Ramakrishnan, as we all know, is a senior advocate and he is a barrister with the experience of 40 years at the bar. He is also a tenant in 33 Bedford Road Chambers, London, and sits as an arbitrator overseas. He has also authored a book titled The Law of Goods and Service Tax, a comprehensive internet age commentary. These are just a few highlights of his illustrious career.
Thank you for your nice introduction, Prithvi. As he was saying, it's a privilege to interact with the third generation of your family. And I have a lot of friends on screen, and it's a privilege to be interacting with you in this today's session. So I've got a PPT, and I'll share the slides and keep talking as we go along. Are you able to see the screen?
Yes, sir.
Okay. Now, this is all about the judgment dated 3rd October of the Supreme Court. I'll divide my speech into three parts. How did this safari retreat arise? And then what does it say? And where does it lead us? Basically, it is the past, the present, and the future. This is how I've divided my talk. Now, safari retreats arose from the judgment, came to the Supreme Court from a judgment of the Orissa High Court Division Bench, and that's reported in 2019 67 GSTR 16, Safari Retreats and the Chief Commissioner CGST. Now, the case arose out of a writ petition filed by the taxpayer. The taxpayer's principal business activity was construction, and he was constructing shopping malls for the purpose of letting out to a number of tenants and lessees. He paid taxes, input taxes under CGST and SGST Acts. He could not avail ITC because of the bar under 17(5)(d). And he filed a writ petition before the Orissa High Court for three reliefs. First, a declaration that 17(5)(d), CGST Act and provisions of SGST do not apply to construction of immovable property intended for letting out on rent. Now, if that was not possible, the alternative prayer was a declaration that the provisions were ultra vires the Constitution. And the third was a consequential mandamus, directing the authorities to grant the benefit of ITC to the petitioner. I think here it will be helpful for you to see the text of the division bench judgment, and that will help you understand how the matter came to the Supreme Court and what the Supreme Court said. I'm sharing the Orissa High Court judgment. Are you able to see it on screen?
No, sir, I think you have to...
No, I'll stop again and share it.
Yes, sir, no, it's clear.
Good. That's it. Yeah. This is the judgment. Safari Retreats and another Chief Commissioner, Division Bench of the High Court. Let's go to the relevant page, which is at page 20. Now, these are the facts. The case of the petitioner is that he's carrying on business activity, constructing shopping malls, and numerous tenants. He's had huge quantities of raw material, inputs, etc., on all of which he has paid CGST and state GST. And he wants to let these out. The problem is he was not able to claim input tax credit. At page 23, it says he is not able to claim input tax credit because the authorities are not allowing him. So he said, got this declaration. Now, the very interesting thing is here, the petitioner has been informed that the authorities' view of the aforesaid section 17D, the petitioner cannot avail of input tax credit, and therefore he filed the writ petition. Now, the interesting thing about this is the judgment runs to a lot of pages, but the reasoning is in the last 2 pages, 2 paragraphs alone. So let's come to that. This is the reasoning. We have heard learned counsel for both sides. The very purpose of the Act is to make uniform provision for levy of collection of tax, intrastate supply of goods and services, both central and state, to prevent multi-taxation. Therefore, the contention which has been raised, keeping in mind provisions of 16(1)(2), a restriction has been put forward for claiming input tax credit, and the benefit of apportionment is subject to 17(1)(2). While considering the provisions of Section 15D, narrow construction put forward is frustrating the objective of the Act, inasmuch the petitioner has to pay a huge amount without any basis. Further, the petitioner would have paid GST if it disposed of the property after completion certificate is granted. In case the property is filed prior to completion, he would not be required to pay GST. But here he is not using it for his own purpose, letting it out, and he still has to pay a GST to which he is not liable. In view of this matter, in a considered opinion, the provisions of 17(5)D has to be read down, and the narrow restriction by the reading of the provision by the department is not required to be accepted, inasmuch keeping in mind the language used in Eicher Motors. The very purpose of the credit is to give benefit to the assessee. In this view of the matter, the assessee is required to pay GST on the rental income arising out of the investment on which he is paid, if he is required to pay ITC, which is required under 17D. In view of the matter, prayer A is granted. That is reading down and saying input tax credit is adjustable, and we are not inclined to hold it ultra-wide. So this is basically the reasoning. And as you would know, the reason, it's very, very short on reasoning. Basically, they have said, look, we read down the provision because the assessee can't be allowed to pay taxes, and the framework of GST is to prevent cascading. Therefore, we are not permitting disallowance of ITC. Now, for a moment, to complete this, let's take a look at Eicher Motors Limited and how Eicher Motors Limited Supreme Court judgment will apply to the facts of this case. Are you able to see it now?
So you'll have to reshare it.
Okay. No.
No. Yes, sir. Can you just zoom in, sir?
Yes. This again, 3-judge bench of the Supreme Court, 1999 to SCC 361. I'll go to the 4th page. The reasoning which the division bench relied on is at the last page, paragraph 6. We may look at this matter from another angle. If on the inputs, the assessee had already paid taxes on the basis when the goods are utilized in the manufacture of further products as input, then the tax on these goods get adjusted, which are finished subsequently. Thus, a right accrued to the assessee on the date when they paid the tax on the raw materials or the input, and the right continue until the facility becomes available, thereto gets worked out, or until the goods existed. Therefore, it becomes clear that 37 does not enable the authorities to make a rule which is impugned therein, and we may have no hesitation to say that the rule cannot be applied to goods manufactured prior to so and so, on which duty had been paid and credit facility availed thereto for the purpose of manufacture. The ratio of this decision was, this is an issue of Modbat and a challenge of a rule under Modbat. The rule could not be retrospectively applied to deny taxation relief, input tax credit relief on goods already manufactured and in existence at the time of the rule coming into force. So if you look at the ratio of the Supreme Court decision, that has really nothing to do with the challenge in Safari retreats before the High Court for three reasons. Number one, Safari retreat was a challenge to the constitutional validity of the plenary registration, whereas this was to the to the rules. Second, the challenge in this particular case, Isha's case, is the retrospectivity of the rules. And third, there was a right accrued in favor of the assessee, and that could not be taken away by the retrospective rules, application of the rules. So these are the three differences in Isha Motors which are not available in Safari retreats before the High Court. So the very basis on which the High Court allowed the writ petition was on a difficult foundation. As you saw, the reasoning of the High Court is Isha Motors observations apply. That reasoning is wrong because we have seen Isha Motors is on a totally different basis. The second reasoning is it's frustrating to the assessee to pay tax and not claim ITC. That is hardly a reason. Frustration of the eye, if that's a reason for invalidating or reading down a provision, I think entire Income Tax Act can be read down to 2 sections. So that's not the basis. I had written in my commentary on this that the High Court decision requires reconsideration. And that is how the matter came to the Supreme. I'll go back to the PBT now.
It's seen, sir.
Pardon?
I can see it, sir.
Good. So the reasoning of the High Court, which we saw, narrow construction frustrates the very object of CGST Act. Now, provision must be read down keeping in mind the purpose of ITC, which is a benefit given to the assessee. And Isha Motors, paragraph 6 applies. To a certain extent, in point number 1 and point number 2, the High Court is correct because the very purpose of CGST and GST laws in general was to prevent the avalanche of increase in taxes. So they wanted to, ITC was a basic fabric of GST laws because they did not want the taxes to be compounded. The compounding effect of taxes were to be avoided. So the narrow construction frustrates the object of GST because one thing we must remember as tax practitioners, both direct, indirect taxes, these are economic legislation. You can legislate away social behavior, but you can't legislate away economic behavior because if you are talking of reducing, denying ITC, then the prices will increase. If you want to maintain the prices, you must have the pass-through effect of taxes. You can't say, I will keep the cascading effects, I will try to negate, or I will retain the cascading effect, but I will not permit ITC. No, it doesn't work that way. You must either have a cascading effect and you have increased prices, or have no cascading effect but maintain the prices passing through of taxes. So to that extent, A and B points of the High Court was good in economic and social philosophy, but not very good law. So let's go to the Supreme Court and how the litigation originated from the High Court to the Supreme Court. The matter came before the Supreme Court at the instance of the